There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner with over 30 years of unbroken service to the community is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340. or 077-127-61884. BWF Solicitors, your trusted legal partner.
Hello. Good afternoon. I hope you are all keeping well. I'm so happy to come your way today for our immigration education program. Today we have no other person than lawyer Eunice Achampong, who is a solicitor and also a partner at BWF Solicitors. Before I delved into the topic we'll be treating today, may I also entreat you to share this program. We will also love to hear from you by sending us your questions or concerns through our social media handles at BWF Solicitors and Vicky Newton. Any of them is fine for us, and we'll be able to pick those questions for Lawyer Eunice to answer them. So we are streaming live on YouTube and Facebook, and I think we are on BWF Radio as well. I am your host, Vicky Newton. BWF Solicitors specializes in family law, immigration and nationality, Ghana law and practice, dispute resolution, and many more. So after this program, and you have any problem or issues with family law, Ghana law and practice, dispute resolution, look no other, law firm than BWF Solicitors. You can also call us live in the studio on 0744-8619-711. Now, delving into today's topic, people are very concerned in regards to your human rights in this country. So Lawyer Eunice picked on that, and they decided for us to talk about making a human rights application as an adult, having lived in the UK for less than 20 years. So if you have lived in the country for 20 years illegally as an adult, will you be able to make a human rights application? That is our topic for today. And Lawyer Eunice will first of all give us an update on, what is happening in regards to immigration. Then, after giving us the update, we will delve into today's topic and discuss the guidelines on how to make such an application for it to be successful. So let me quickly introduce Lawyer Eunice. Hello, Lawyer Eunice. How are you doing?
I am doing
Nice
very well.
to see
How are
you.
you?
I'm good.
It's good
Today's
to see that
another.
Audrey also celebrated her birthday. I'm
Yes,
so glad for her.
yes,
So
Audrey. Oh,
Audrey
that
is,
reminds me.
let me just introduce Audrey. Audrey is Vicky's daughter. So Audrey is celebrating her birthday today. We
Thank
wish
you.
her a happy and blessed birthday. And for God to grant her many, 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 many healthy and blessed years.
Amen.
May she move forward with
Amen.
wisdom, knowledge, and
Amen.
understanding in all that she does. Yes.
Amen. 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 Lawyer Eunice, thank you so much. Honestly, I didn't want to come out with it, but I think you've let the cat out of the bag. I was like, oh, we're talking about immigration. So what has birthday got to do with this? So let me just keep it to myself. But you've let the cat out of the bag. I'm so happy. She's my first child. She's a
Yeah.
lovely, wonderful child. She's been a blessing on me, and so is her siblings. So, Laura Eunice, you know what you've done to me. I'm also going to wish your husband happy birthday in advance, which is on Monday, bank holiday. I'm going to come to your house for the birthday barbecue. Yes. So happy birthday to Lawyer Eunice's husband.
Oh, thank you.
Would you like to say something lovely?
Oh, please. With my husband, he's Augustine. So
Yeah.
with Augustine, a lot of people hear his name and they think, oh, is it because you were born in August and that's why
Right.
Augustine? And obviously, I think his dad was Catholic and with Saint Augustine, so
Right.
his dad decided to name him Augustine. And to me, my husband has been a very strong pillar since we got married, and I know that with this birthday coming up, the Lord will continue to extend him and will continue to cause him to go even further and beyond than he even thought or imagined. So I know that God is just going to do greater and more in his life from henceforth. Yes.
Oh, wonderful. You guys are such a great team.
Thank
Right.
you.
So, Lawyer Eunice, back to today's program. I know before we talk about the topic, you're going to give us an update. People can't wait to hear, what updates you have for us. So, Lawyer Eunice, take it from there.
Okay, so let me say a big hello again to our viewers, those that are watching us from wherever you are in the world. I say a big thank you for joining the program today, and I hope that you are all doing well by God's grace. If you can, please share the program with somebody that you know who will benefit from it so that they can also have that awareness about what is going on and hopefully they'll be able to advise themselves accordingly. Okay, so in terms of our updates, we're going to look very briefly at changes that came to play towards the end of July 2023. And obviously, we know that there have been changes in regards to students who are here in the UK and also those that are students who want to switch onto the skilled worker route here in the UK. There was a lot of news publicized about the fact that the government wanted to sort of curb immigration numbers, and so they were looking at how to do so by limiting the number of dependents that were coming in for students, and then they were also looking to curb those students who, for instance, came into the UK and were not able to complete their courses. They obviously looked at how they could curb them from switching on to the skilled worker route. So I'm going to briefly look at the statement of changes that were introduced, and I hope we are going to benefit from the slides that are going to be shown. So,
Okay.
in terms of the student route, I know a lot of people are aware that our statement of changes that were introduced on the 17th of July made very significant changes to the immigration rules, such that if you were here and you knew that certain changes take time to be implemented, they did it such that all the changes that they were hoping to implement were implemented on the same day. So this is the statement of
Oh,
changes to the immigration rules, which Parliament introduced
okay.
on the 17th of July 2023. And so when we
Okay.
quickly go to the introduction page, it says implementation. The following paragraphs will take effect at 3 on the 17th of July 2023 in relation to those changes if an application for entry clearance, leave to enter, or leave to remain has been made before 17th July 2023. Such applications will be decided in accordance with the immigration rules in force on the 16th of July 2023. So basically, they're saying that the following paragraphs should take effect from 3 p.m. on the 17th of July 2023. But we're not going
Okay.
to look at all the paragraphs, that we're just going to look at 3 bullet points, and then that will help us with today's updates. So here it says intro to, and then it also says appendix ST1 and appendix ST2. ST stands for student. So when it says ST, we know it's students. So appendix student, paragraph 1, and appendix student, paragraph 2. And then we
Okay.
also have here appendix SW1 and appendix SW6. SW stands for skilled worker. So skilled worker means those that are coming into the UK or are in the UK with skilled worker visa. So appendix skilled worker paragraph 1 and appendix skilled worker paragraph 6. So we are going to look at what the actual paragraph states under our statement of changes. So
Okay.
when we look at the introduction, it says introduction paragraph 2. In paragraph 6.2b, so it doesn't even state in paragraph 2, it states in paragraph 6.2b. So it's referring to a different paragraph than paragraph 2. It says that after the definition of overseas business, insert this new definition. So we're going to look at what research-based higher degree means. So it says research-based higher degree means a postgraduate program comprising a research component, including a requirement to produce original work that is larger than any accompanying taught component when measured by student effort. So what they're trying to say is that when they are talking about a research-based higher degree, they expect that your research component, it could be a dissertation. So your dissertation has to be awarded more marks than your modules that will be taught. So let's say,
Okay.
for instance, I've come to the UK, I want to study a master's program. And in terms of my master's program, I'll be doing a dissertation, and then there are certain modules that will be taught as well. If my research and dissertation is going to carry more marks, let's say 51% overall marks compared to my taught modules, that in itself makes my course a research-based higher degree. So
Oh,
they're basically saying that your research or your dissertation has to be larger than the taught components or the modules that you will be taught in as part of your course. So if you're able to establish that your dissertation is going to carry more marks than your modules that are going to be taught, then you know that you are in a research-based higher degree. And we're going to look at why this definition of research-based higher degree. So as we go down to the student appendix that were introduced, it will state very clearly what they meant by the research-based higher degree, because a lot of it has to do with the fact that there were certain changes that were going to take effect from the 1st of January 2024. So let's read. Appendix Student, paragraph 1. At the end of Appendix Students, paragraph 31.1b. So again, even though it stays Appendix Students, paragraph 1, when we read it, it's not referring to paragraph 1, it's referring to 31.1b. So it says that at the end of Appendix Students, paragraph 31.1b, after a higher education provider with a track record of compliance inserts, if the course start date is on or after 1st January 2024, the provider has confirmed the course is a PhD or doctoral qualification or a research-based higher degree. So a little background to this is the fact that they're expecting that if your course is a research-based higher degree, it has to be a course which will start on this date here, the 1st of January 2024, because they have made changes in terms of those students who can bring their dependents to the UK. So in terms of those students who can bring their dependents to the UK, we're going to see very soon that when it comes to the fact that they have the opportunity to bring their dependents, it is all those who currently have undergraduate courses, foundation degrees, let's say diplomas, any course that you have been granted a CAS for, those people are still able to bring their dependents. So the key date that has been listed on this statement of changes is the 1st of January 2024 for those students who would obviously be having dependents come after the 1st of January 2024. Yes, so very quickly, let's see what it says in our immigration rules in regards to those students. So as we can see, it's appendix students, sorry. And when it comes to dependence of a student, which under our statement of changes, we realize that paragraph 28.4 has been amended so that those people who want to bring their dependents, so it could be a friend or a child or a wife, those people will be able to take note of those changes that will take effect from the 1st of January 2024. So let me just scroll down, sorry. We can see at the top that it says dependence of a student, and then it says validity requirements for a dependent partner or dependent child of a student. So we're looking at what will make the application valid. So if the application is not valid, then you can't even make the application in the first place. So it says under paragraph 28 point, let me just put it here. Yes. So under paragraph 28.2, an application for entry clearance or permission to stay as a partner or a child of a student must meet all of the following requirements. So the paragraph A says that any fee and immigration health surcharge must have been paid, and the applicant must have been provided with any required biometrics, and then the applicant must have provided passport or other travel documents which satisfactorily establishes their identity and nationality, and the applicant must be applying as a partner or a child of a person who has made a valid application for entry clearance or permission to stay on a student route that has not been decided, or has entry clearance or permission to stay on the student route. And then it goes on to say that at 28.4, which is the one that we're interested in, it says that an applicant who is in the UK on the date of the application must have or have been last granted permission, must not have or last have been granted permission as a visitor, as a short-term student, as a parent of a child student, as a seasonal worker, as a domestic worker in a private household, or outside the immigration rules. And the application which does not meet the validity requirement for a partner or a child, uh, on the student route is invalid and may be rejected. So it means that if you are making such an application, you shouldn't have been in the UK already on any of these visa routes. And if you go on to look at the eligibility requirements under 31, it also says that under appendix student paragraph 31.1, unless they are a child who meets the requirements under appendix student paragraph 31.2, the applicant must be the partner or the child of the person who is a student who has received an award from a government and has or is applying for permission to study on a full-time course of 6 months or longer. So paragraph B says that if they're a full-time student who has or is applying for permission to study a postgraduate level course of 9 months or longer at a higher education provider with a track record of compliance, and if the course start date is on or after 1st January 2024, the provider has confirmed the course is a PhD or other doctoral qualifications or a research-based higher degree, and then a C is deleted. So they're basically trying to say that if you're applying as a dependent of a student, whether you're a partner or a child, you have to make sure that you are not on any visa route that disqualifies you from applying, first of all. But if you are a student who obviously is saying that you want to bring your dependent, then you should be able to show that at least the student who is here in the UK is going to be a student who is studying a research-based course, a PhD course, or a doctoral qualification by the 1st of January 2024. And therefore, those students will be the only students who will be able to bring in their dependents from that date. So as it is, those that are dependents can also make applications to join their student partners or parents at the moment. But from the 1st of January 2024, changes will take effect, and it would mean that only those students who are studying a research-based higher degree, as we looked at, or a PhD, or a doctoral qualification will be able to bring their dependents. So if you are looking to bring your dependent after the 1st of January 2024, you must make sure that your course of study is a course that is research based. And we saw that a research based higher degree is a degree where your research or your dissertation carries more weight or more percentage than the actual modules that you'll be taught. So if your dissertation is going to carry 52% of your overall marks at the end of the course, then you know that it's a research-based higher degree. So that's, I think, key to.
So, okay. So is it the same as masters?
Yeah, it could be a master's.
PhD.
Obviously, yes, there are some degrees that, of course, apart from masters, some people may do postgraduate degrees that are more research based.
Okay.
So it might be that they are doing a qualification which demands that they look at a specific study area or whatever it is.
Okay.
Um, Looking at people who do things like medicine and biochemistry and those kind of subjects, or that obviously require a lot of research and the rest of it. So when it comes to people who study those kind of subjects, I am always careful to make sure that those people will be able to explain further. And I'm sure within every course subject, the modules are explained. And if you need to do a dissertation, it will be explained to you that this is how much your dissertation carries in terms of your overall marks as well.
But Lawyer Eunice,
Yeah.
what brought about these changes? Because I feel if you are studying, your degree course, you should have equal rights as someone doing his PhD or master's. So
Yeah.
why that, decision? What has led to that? Because
Yeah.
I feel that even if you are doing your degree course, you might definitely, because most of these degree course takes about 3 years to
Mm,
complete. So living alone without being able to, bring in your dependent, your partner, or
mm,
probably your children, then rather giving the opportunity to, those doing their masters or research-based, courses.
yeah.
What led to that? Because I don't really get it. A
I think
student is
it's
a
a number
student.
of different factors. I know there are those students that come in
Mm,
that haven't obviously um, been able to complete the course that they said they were going to
right,
complete.
right,
So I'm sure within their system, the Home Office has a way of checking those students that came in with undergraduate degrees, those students that
okay,
came in with
okay,
foundation degrees, those students that have come in to do a master's degree, and are able to tell those students who were able to actually complete the course after they finished. And if based on their records, they can see that those students are not able to complete their courses. They want to serve it as a deterrent, basically, to say,
right, okay,
because you haven't completed your courses, we are not going to allow you to have the privilege of bringing your dependents with you,
mm,
because we are
okay,
looking to curb immigration numbers anyway. And also,
okay,
I know the government wants to retain the best of the best.
of the
They want
best,
to make
yeah,
sure that Britain is basically being moved on by those who are research based and those that are able to
right,
move the economy forward and other things. So I'm sure it's to do with a number of different factors as well.
okay,
Yes.
okay, that's understandable.
Yes. So very quickly,
Mm,
we're going to look at the appendix student and what obviously the government is saying in terms of those people that have actually come and are basically here as students, because a
okay,
number of students thought they could switch to the skilled worker route without having to complete their course, and that
yeah,
was curbed on the 17th of July 2023. So
mm-hmm,
under Appendix Skilled Worker, it says Appendix Skilled Worker Paragraph 1. After Skilled Worker Paragraph 1.5, insert
mm-hmm,
Skilled Worker paragraph 1.5a, an applicant who is applying for permission to stay. So
Yep.
if I'm here and I'm applying for permission to stay,
Okay.
and I was last given permission as a student, I
Mm-hmm.
must fulfill one of the conditions A, B, C, or C below on the date
Okay.
of the application. So,
All right.
condition A says the applicant must have completed the course of study for which the confirmation of acceptance of study was assigned. So it's
Okay.
saying that if you are here in the UK to complete, let's say, a foundation degree in medicine or a law professional course or a diploma in another subject, then
Yeah.
you must show that you have completed that course because you were granted a CAS, which is the confirmation of acceptance of study.
Yeah.
Now let's look at option B or condition B. It says that the applicant must be studying a full-time course of study at degree level or above with a higher education provider which has a track record of compliance, and the certificate of sponsorship must have a start date no earlier than the course completion date. So this
Mm.
again is referring to those who are doing degree level courses like an undergraduate degree or a master's degree, and it's
Okay.
saying that they should be able to show that they have been granted a certificate of sponsorship to work once their course has been completed.
All
So
right.
they cannot be granted a certificate of sponsorship if their course has not been completed.
Okay.
And then condition C says that the applicant must be studying a full-time course of study leading to the award of a PhD with a higher education provider which has a track record of compliance, and the certificate of sponsorship in SW 1.2 paragraph D must have a start date no earlier than 24 months after the start date of that course. So basically, what we are saying here is that if you are studying a PhD degree,
Yeah.
then make sure that your work or the certificate of sponsorship that you have been granted for work is not starting earlier than 24 months. So if you have completed 24 months of your degree or your course, then
Yeah.
you can obviously have a certificate of sponsorship that will start after that period of time.
Time.
And then let me jump straight to SW6. So it says that after paragraph after appendix XW 26.4, insert skilled worker paragraph 26.48. An applicant who is applying for permission to stay and has last or had last had permission as a student must fulfill one of the following conditions. So
Mm.
if you're applying for permission to stay and your last visa shows that you were a student, then you must be able to fulfill one of these conditions before you can switch to the skilled worker route. So
Okay.
condition A says that the applicant must have completed the course of study for which the confirmation of acceptance of studies was assigned, exactly like what we read at the top. Or
Mm.
condition B, the applicant must be studying a full-time course of study leading to the award of a PhD with a higher education provider which has a track record of compliance and has completed at least 24 months of study on that course. So it's basically but trying to tell us that we should make sure that if you are a student and you are here in the UK and you say you want to apply for permission to work, then you should be able to make sure that you have completed your course of study under
Okay.
SW 1.5. And then
Mm.
under SW 26.4 is looking at exactly those people who are applying as dependents. So when we look at our immigration rules, if you say you are applying as a dependent of a skilled worker, so let's say that I am here as a student, my husband is a doctor, and I haven't been able to complete my course, and I want to switch to my husband, who is a doctor or a skilled worker here in the UK. I
Yeah.
cannot switch as his dependent if I have not been able to show that I completed my course. So, under the immigration rules, um, SW 1.5 is, it's basically to do with, let me just show us the heading,
Hmm.
the validity requirements of a skilled worker. So,
Skilled
if
worker. Hmm.
I say I'm in the UK and I want to switch onto the skilled worker route, I must meet the validity requirements, including that which is under SW 1.5. So I must be able to show I'm not a visitor, I'm not a short term student, I'm not a parent of a child student, I'm not a seasonal worker, I'm not a domestic worker in private household, or any person outside the immigration rules. And then exactly under 1.5A, I should be able to show that if I'm applying for permission to stay or was last granted permission as a student, I must be able to fulfill the conditions as we read under the statement of changes. So all the conditions have to do with me completing my course as a student. And then if I go to this section here as dependent, so dependence of a skilled worker, we're going to be looking at paragraph 26.4 as in the statement of changes. So under paragraph 26.4a, it says that an applicant who is applying for permission to stay and has last or was last had permission as a student must fulfill one of the following conditions. So if I'm a partner or I'm a child of a skilled worker here in the UK and I was last given permission as a student, then I must be able to show that I have completed my course of study as under condition A, or if I'm a PhD student, I must be able to show that I've completed at least 24 months of my study before
Okay.
before I'm able to switch on as a dependent of that skilled worker under
Okay.
condition B.
Hmm.
So this is basically a brief of the changes that came into effect once the government introduced it on the 17th of July. They did not
Hmm.
give anybody breathing space to even try and complete applications. All they said was by 3 p.m., if you haven't made your application, then of course you cannot switch as a student onto the skilled worker route. And
Right.
if you are a student who wants to switch onto your partner who is a skilled worker, you also would not be able to do so because we have limited that number of,
No number.
yeah, should I say, applications, and we are no longer going to accept students switching onto those routes if they haven't completed their course. And
Okay.
because it means they've caught on, because I could see that the news agents were really catching on to people who have decided to come to the UK and basically not study.
It's
And
true.
it was amazing the numbers of people who were even going to the news agents to basically say, well, we are bringing in a lot of people. They are not coming to study. They are just coming here to live, work, and then be able to fend for their families. And
Oh,
it
yeah.
was terrible to see some of these things on news,
Mm,
because of course
mm,
it means
mm,
that you are opening the floodgates for them to
exactly.
obviously curb all these things,
Mm,
because obviously they see it as an illegal way of
yeah.
trying to get into the country.
Mm,
So
mm,
obviously that has made them more alert in terms of curbing the immigration numbers as well. And then, secondly, when it comes to those applications under the EU as well, I know a lot of people have received emails, they've received notifications to let them know
mm,
that there's this automatic extension of 2 years, and some people have also received that notification that if you have settled status and they can see on their records that you have reached that period of 5 years for you to be granted settled status, they can grant you settled status straight away. And
Mm.
so I wanted to explain a bit more on that. So, for those who are EA nationals living in the UK, or for those who are family members of EA nationals living here in the UK, when it comes to applications that you have done for pre settled status or for 5 years limited leave to remain,
Yeah.
if for any reason you have received any notification, or even if you haven't received any notification, due
Mm.
to case law, the government have decided that if your pre-settled status application obviously comes to an end, so you were granted pre-settled status, which is limited leave to remain, and it comes to
Mm.
an end, and you haven't made an application to be granted further leave, or you haven't made an application for settled status, they are supposed to grant you a further 2 years so that you would not become illegal in the UK. We all know that under our previous EA regulations, 2016, as long as you remained a family member of an EU national, or if you were an EU national yourself and you were a qualified person,
Yeah.
that meant that you were here legally. You didn't have to have a form of document to show that you were here legally. The very fact that you were working, or you were a self employed person, or you were a family member of an EA national made you legal. So, obviously, this court case made it apparent that they should continue with that same mindset, so that people who are not able to apply for their settled status in time do not become illegal in the UK. And so, from the new guidance that the Home Office have brought, it shows that they are willing to extend those whose leave to remain is coming to an end for a further 2 years. If you know that your time for settled status, so let's say that you made an application in um, August 2020, and you know that your 5 years will be up by August 2025, you can make the application for settled status even if they have granted you an extension of 2 years.
Mm.
The precaution is that, of course, if you forget to make the application, you are not here illegally.
Okay.
So, even though they may grant you an extension of 2 years, getting to your expiry date,
Mm-hmm.
you will still have the right to make the application for settled status once your 5 years continuous residence is up. So, if you are saying August 2025 is your set time for your uh, expiry of your residence card, or you know that you have been a family member of an EU national for a period of 5 years, then you would be able to make that settled status application, even with the 2 year extension that they give to you. They just want you to obviously make the application, and then if they have to grant you settled status, they will go ahead and grant you settled status. And so I just wanted to make people aware of those changes that have been brought about due to the case law that obviously made it possible for EU nationals to continue living here and their family members to continue living here, even if they didn't apply for settled status.
Oh, okay.
So I'll leave the
All right.
updates here for
Oh my goodness, Laura Eunice, I think you've taken about 97% of
Yes.
our time with the update, which is very good. At least for a change, we've had a very lengthy, update, which is very, very, very vital and very important. So I think
Yeah.
this show will be extended by extra few minutes for us to be able
Yeah.
to delve into today's topic. But in fact, it's been insightful. I believe that this cannot be absorbed immediately,
Mm,
or and you've explained everything to us, but I believe that everybody watching us should go back after we've finished with the show. Go back on our YouTube page at BWF Solicitors and take your time and go through whatever Lawyer Eunice took us through. And that will give you a better understanding. If you don't, you are not clear with anything Lawyer Eunice said, she'll be leaving her contact details for you to give her a call. But that was very insightful and a very good one. Lawyer Eunice, thank you so much for those wonderful updates. So if you've just joined us, this is Hanging Out with BWF Solicitors. Today's topic is, can I make a human rights application as an adult, having lived in the UK for less than 20 years? And if this is the first time you've joined us on this platform, Lawyer Eunice is our in-house solicitor. She is a solicitor, as I said previously, and also a partner at BWF Solicitors. She'll be taking us through this topic and also giving us guidance how to make such an application. If you have any questions or you're not clear about anything that's been discussed here, please feel free to send in your messages on our social media handles, Facebook and YouTube, where we are streaming live, and I'll be able to pick those up, and Lawyer Eunice will answer those questions. I am your host, Vicky Newton. So, Lawyer Eunice, who is eligible to apply for leave to remain based on the private life in the UK?
So when it comes to those that are, should I say, living here illegally,
Yeah.
one of the main applications that they are able to make is a human rights application. So if
Mhm.
you are living here illegally, the chances are you are basically not going to be able to make an application on any of the routes that I've mentioned, such as the skilled worker route
Mhm.
or the Appendix EU or the student routes or any of the main routes that we have under our immigration rules. And so those who are here illegally, or should I say, have overstayed their visit visa, for instance, or any other visa that they may have, will mostly have the right to make a human rights application. What I
Okay.
mean by a human rights application is an application under Article 8 of your human rights. So, Article 8 of our Human Rights Convention states that we have a right to private and family life. But
Okay.
this right can also, should I say, be um, limited by the home office or the government. So it's not an absolute right, like a right to life. A right to life is
Okay.
an absolute right which the government cannot interfere with whatsoever. But a right to your private or your family life can be interrupted by the government if it is against public policy, for instance. So if it's against the laws of the land, if it's against public health because maybe you have some form of disease that they don't want to catch, or if they think that it's against their basically their way of conducting life here in the UK. So that
Okay.
is the only limitation in terms of a person's human rights in terms of their family or their private life. And so if somebody is here in the UK and they're saying they want to make an application based on their private life,
Mhm.
then it means that they have no partner, no child, and therefore they are making their application solely based on themselves. And they
Okay.
want to make their application because they are above the age of 18. And it shows that they have lived here for a length of time, and that's why they are making the application. Under our immigration rules, if you are showing that you have lived here for at least a period of 20 years, they consider that having, should I say, that length of residence as a very long time to be away from your country of residence. So you
Yeah.
have to be able to show that you have lived here continuously for a period of at least 20 years to be able
Right.
to make an application based on your private life. But if you haven't lived here for 20 years, they also have the requirement under Appendix Private Life 5.1, where they say that if you have lived here for less than 20 years and you can show that there will be significant obstacles to you integrating into your life in obviously the country that you're from, then of course
Yeah.
we will consider that as well. So when it talks about private life applications, it's mostly talking about a person making an application based on their length of residence here in the UK.
Okay. Okay. So, if we talk about eligibility, is
Mm.
this topic focusing on those who don't have children or partners, but they are making
Yes.
the application solely by, because I knew years ago, for you to make such an application, then you can rely on the family life, that is children and a partner.
Mm. Yes.
Okay. So, all right. Okay.
Yes,
Okay.
yes. So basically, for those who have not got children or a partner that they can rely on, then their length of residence will come into play. And then obviously, it depends on how old they are. So if you look at
Right.
our appendix private life, if I
Mm.
was under the age of 18, let's say I was 7 years old, and I can show that I've lived here since I was born, I
Yeah.
can immediately make an application for indefinite leave to remain because I have lived here continuously for 7 years as a child. If
Okay.
I was under the age of 18 and then I was saying that, well, I've lived here for quite some time, I haven't got a wife or a
Mm.
husband or
Mm.
any children because I'm under the age of 18, but I want to be able to show that yes, I wasn't born here in the UK,
Yeah.
but I have lived here for a period of 7 years. That person can also show that yes, because they've lived here, not because they've lived here illegally, but at least they have lived here legally for at least 5 years. They too
Okay.
can make an application for indefinite leave to remain because of the fact that they are under the age of 18. And
All
so
right.
those that are above the age of 18, where they are looking at their private life, are those that have been able to show that they've lived there for at least 20 years, or if
Mm.
less than 20 years, then uh, are there any significant obstacles to their life continuing outside the UK?
Okay. So that leads me to my next question. What are the requirements to be met under
Mm.
the appendix private life of the, the immigration rules?
So when you're looking at somebody who has lived here for less than 20 years, like I'm saying now, that
Mm.
person has to be able to show that if they are making their application, they have lived here continuously
Okay.
for less than a period of 20 years.
Mm.
So, yes, I've lived here continuously. So, continuously means that you haven't been out of the UK for a period of, let's say, 6 months or more within a given period of 12 months. So,
Okay.
I've
Okay.
lived here continuously
Continuously. Okay.
continuously for a period of less than 20 years. So, yes, I've lived here for less than 20 years. And then I'm also telling them that I think that there will be very significant obstacles to me going
Mm.
back to the country where I am from. They haven't really given a definition for significant obstacles, but
Mm.
they have put in their policy guidance that when they are looking at significant obstacles, they are looking at things that are very difficult or serious situations that will inhibit a person from integrating into life in their country.
Okay.
So if they're looking at serious circumstances that will inhibit a person from integrating into their country, then obviously you can be looking at things like sickness, you can be looking at things like wars, you can be looking at things like their life being in danger, risk to their life if they were to return. You could be looking at their religious or political views that are not tolerated in
Okay.
their country of origin. So it may include a number of factors in itself. Yes.
Okay. All right. Gloria is saying, can such an application be done by yourself, or is it that complicated and therefore you will need a solicitor to put in that application for you? Secondly, she also wants to know what laws can she use to support such an application. That is, if it's advisable for her to do that single-handedly.
Okay. So it depends, of course, on her situation. But I would always say that when you are making a human rights application based on your private life, and it's not as straightforward as me having a child or as me having a partner that I'm relying on here in the UK, I would always say it's best to see a solicitor because
Okay.
human rights applications are not as straightforward as people may think, especially in this case where there are a lot of different factors involved and there's no definition for significant obstacles.
Okay.
Definitely, you will need to see a solicitor to help with the application, and then they can direct you as to documents
Right.
you can also
Okay.
provide in terms of the application as well. And when it comes to case laws, it becomes also a necessary thing that you have to involve somebody who is well versed with the law
Mm.
than just yourself, because obviously you are not, should I say, legally trained
Okay.
to be able to look at case laws and look at what the law says about such a human rights application. So,
Okay.
for instance, let's say that when it comes to me making an application because I have an illness, so basically, I'm physically disabled, for instance, and therefore, there's no way that I could go back to my country of origin. They're going to look at what your disability is. Is it something that is affecting your everyday way of life? Is it
Yes.
something that you are saying that without the support and help of carers or people around you, you would not be able to cope? They'll be looking at what help will be available to you if you were to return to your country of origin as well. They'll be looking at things to do with not just yourself, but if you do have um, ties here in the UK. So things like cultural ties. So cultural ties could mean that, for instance, you are very much involved in terms of the way that we do things here in Britain. So you
Mhm,
speak
mhm.
the
Okay.
English language, you
Okay.
are somebody who is able to integrate well within your community. And so they want to know, do you have any cultural ties here in the UK? Are
Okay.
you very much part of the community that you are from? They want to look at things like extended family members. What family ties, for instance, do you have here?
You
Even if
have.
you don't have a husband or a wife or a child, do you have extended family members here in the UK? They
Okay.
also want to look at things like somebody who is got a medical situation, like I mentioned. What are the care provisions that are there in terms of that person actually integrating into life in their country that they are from? And would there be obstacles to them actually living their life as they should? Because obviously, when it comes to medical issues, we know that under Article 3, a person also has a right to not be tortured or not to be degraded in any shape or form. And so,
Exactly.
if you are saying that this person should go back to their country of origin and they will not have any support whatsoever, they will not have access to treatment because obviously they are not working or they haven't been able to save money to be able to afford the treatment,
The
then you are
treatment.
basically telling them they should be able to go and have a degrading life and then eventually
Mm.
die. So, of course, these are very high thresholds when it comes to Article 3 cases because they're thinking, is that going to lead to death? If they think that it will not lead to death, then obviously the government will say, hey, this is not a situation that is likely to lead to death. But if we are supposed to look at the factors that I've just mentioned in terms of cultural ties, family ties,
Mm.
obstacles to you living in your country of origin, um, obviously, when you look at those situations and those factors that I've just mentioned, then that is looking at your private life, Article 8, right, where they have to consider whether it will be proportional to send you back to your country of origin or
Mm.
to cause you to remain here. And cases such as AM Zimbabwe, that was decided in 2022, give a criteria that the caseworker has to look at when deciding these cases, because when it comes to private life applications especially, they have to consider these factors before they go ahead to decide whether or not to grant you leave to remain in the
Mm.
UK.
Okay. All right. Right. Ladies and gentlemen, if you just joined us, this is Hanging Out with BWF Solicitors with your host, Vicky Newton. With me is lawyer Eunice Achampon, who just spoke. She's a solicitor and also a partner at BWF Solicitors. If you are wondering what are these ladies talking about, yes, today's topic is, can I make a human rights application as an adult have having lived in the UK for less than 20 years? Can I make a human rights application as an adult having lived in the UK for less than 20 years? So Lawyer Eunice was taking us through the eligibility criteria for one to make such an application. If you want to contribute to the program or ask your questions, of course, you can do so on our social media handles, Facebook, YouTube, at BWF Solicitors or Vicky Newton. If you also want to contact us live in the studio, of course, you can do so on 0744 8619 711. The number again is 0744 8619 711. If you are not the talking on the phone type of person, you can send me a WhatsApp message and I'll definitely be able to ask Lawyer Eunice that question on your behalf on the same number, 0744 8619 711. Right, back to you, Lawyer Eunice. I've got Musa who sent this question. It's a very lengthy one, Lawyer Eunice. Musa says, good afternoon, ladies. I really enjoy your program. Thank you. My question is, I have lived here for more than 6 years and I have no children or partner. I made an application for asylum about 2 years after I arrived as advised by my lawyer. I requested for permission to work and a card was brought to me. I have been working since. The reason I put in the asylum application is because I am from Nigeria and the son of the chief. Due to security threats, my father sent all his children abroad. I have still not heard from Home Office. Can I make another application based on private life? Or do I need to show evidence of any illness, family ties in UK, obstacles to living life in my home country? Eunice,
Okay.
I
So
hope you were able to grasp everything. It's really a lengthy one.
yeah. So I think this person is basically saying that they've come here, they've put in an asylum claim
Yeah.
since they came. They've lived here for at least 6 years, and they want to know, can they actually make a private life application because they haven't heard anything since they
With
put
their
in
asylum application. Okay.
asylum claim. When it comes to, I think the first part of the question said, can he make the private life application, isn't it?
Exactly. Yes.
Okay. So in terms of him making a private life application, yes, he's lived here for 6 years, which is less than the 20 years that I was talking about.
Yeah.
But in terms of him showing whether there are significant obstacles, he says that he's the son of a chief,
Right.
and due to security reasons, they've had to
Mhm.
move.
Yeah.
Um, Obviously, the Home Office caseworker will also have to look at whether the application is on the basis of his private life and whether he has very strong claims in terms of the factors that I also mentioned. And
Mm.
if refusal of his human rights claim will be a detriment to him as well. Um, when he says that his father has sent them all abroad, I I don't know the specifics of it, but I
Mm.
know that when it comes to royal family and the fact that sometimes other um, people who are not so much for the royal family or maybe against the royal family are likely to target the children because those children will end up becoming heirs to the throne. So, of course, if that is the danger that the children are facing, then he has to provide evidence that there is that danger um, in place. So whether it's the fact that there's a tribal war or there are people who are very much against the family um, being in power, so there have been threats to their life, for instance. So maybe
Yeah.
attempted robbery, attempted ways of basically deterring the children from going to school and all of that, those
Mm.
threats will have to be basically picked up. So if maybe supporting affidavits from people that know the royal family or the chief himself
Mm.
provide evidence that these are the threats that have gone on, and because of that they are no longer safe, and therefore they feel that the children should be elsewhere, then of course I think that he might be able to put in a claim
Okay.
based on his private life, because that may amount to a significant risk of harm to their lives if they were to return to their country of origin. So I think
Okay.
it's a case by case basis, but he needs to provide evidence to that effect. And as I said, the Home Office are also going to look at whether you have other ties as well as
As well. Mm.
obstacles. So in um, balancing your right to private life, they're going to ask, is this person also somebody who has extended family members, for instance, here in the UK? They're going to be looking at your length of residence. In his case, he's lived here 6 years.
Yeah.
Maybe because his siblings are here, maybe that will help in terms of the fact that um, he has some extended family here with him in the UK.
Mm.
It could help in terms of his the fact that he's also a bit maybe culturally involved. Maybe he's been to school here in the UK, or he's worked, so he probably has a way of um, speaking the English language, because he says that he was granted work permits as part of
Yeah.
his asylum claim. So he has colleagues, and therefore he may have integrated into the British way of life in some way, shape, or form.
Okay.
Obviously, they will have to look at those other factors and see whether, in doing so, a refusal will then be to the detriment if they don't um, allow his application under Article 8. So he may stand a strong chance of having the application being successful if he's providing evidence to that effect.
Okay. All right. So there you go, Musa. Noah Eunice has answered your questions, but if you still need clarification or need more advice, to put in that another application, Lawyer Eunice will leave her details at the end of this program, and you can contact her, book an appointment, and she'll be able to help you. Right. So I've got another question. Yeah. This lady, I think she's Sewa. Yeah, Sewa. You mentioned certain factors that the Home Office will consider when deciding whether refusal will not be in breach of Article 8 rights. I want to know if I have no family in the UK, but a friend who has been very supportive and helpful, even when I was diagnosed as blind. Would that make I think the handwriting, would that make me, I think she's trying to say that can she apply for the application under private life? Would that make it successful for her to put in such an application?
Okay.
Yeah.
Okay. So, in terms of her question, I know she's saying that she's blind,
Yeah.
and obviously, considering the factors that I mentioned, she's not very sure if her application will be successful if she were to put in an application for private life.
Okay.
First of all, I don't even know how long she's lived here. So, of course, depending on how long she's lived here, if, for instance, in her case, maybe she's lived here just about 10 years, because that's one of the factors that they also consider,
Consider.
your length of continuous residence. So if you've lived here for a long period of time, you are saying that you've made some form of cultural integration in terms of living here in the UK, even though you're blind, you have friends here, you are part of a community.
Yeah.
You are saying that apart from being part of a community, um, you don't have any family members, but at least you want to be able to know, if you were to put in the application for private life, having lived here less than 20 years, what will the success rate be?
Yeah.
So, apart from her having a friend or maybe friends that she is close with, they want to know what her length of residence is. And as I said, if she's lived there for like 10 years or more, they may consider her length of residence. If she's
Resident.
involved in things like her church community, or she does things voluntarily within her
Okay.
community, they may consider things like that as well. If this person is also saying that they have been able to show that there will be significant obstacles to life continuing outside of the UK. So, for instance, because of her illness, she's saying that she's not going to have that support. Maybe she hasn't got family back home. So there will be no support because she hasn't even got the money to be able to ask for that support because she's blind. And she's also saying that maybe because of her blindness, she's not going to have any form of treatment that will be able to cure her from her blindness.
Okay.
So obviously, in that sense, going back to her country of origin may then be a risk to her living her life the way that she would want to. At the moment, I know that there are school for the blind. They teach you how to cope and do daily activities as a blind
Yeah.
person.
Yeah.
Obviously, the government might look into whether that is existing in your country of origin and whether you'll be able to attend School of the Blind and be able to adjust, because obviously blind people live everywhere in the world. So if it would not be a deterrent, because they don't see it as being a risk to your life. So they may look into whether those facilities are available in your country of origin. So if those facilities are available, then it may mean that you will end up not having so much of a strong case, because obviously they want to be able to balance the different factors apart from the fact that you have friends. So, how long have you stayed here? What are your ties in terms of your cultural ties to your community? How well do you speak the English language? How well are you integrated into life here in the UK? What are the obstacles to you going back? Do you have an illness? In her case, she has an illness. Do you have any political view that will be a threat to your life? Um, Obviously, we haven't spoken about sexual orientation, but obviously, somebody who may be homosexual may not be accepted in most African countries, because most African
Yeah.
countries do not accept homosexuality.
Yeah.
And so they look at all these different factors and then they balance whether these factors will be an obstacle to you integrating into life in the country that you are from. And if in balancing those factors, the caseworker believes that a refusal is still possible in terms of you not being able to meet your right to life, I mean, right
Life.
to private life here in the UK, then they may suggest that you go back to your country of origin, because there are other avenues by which you would be able to live life peacefully. It's all to do with how well you are able to balance those factors.
Oh,
It's not easy, obviously, trying to meet that threshold of serious inhibitions to you living that life in your country of origin. But
origin.
of course, there is that balancing act that they have to meet. So when it comes to Article 8, they are not necessarily looking at just the serious inhibitions, they are looking at balancing those factors in regards to your private life here in the UK. So they are basically trying to do a weighting or a balancing act and say, okay, we see that these factors are what is preventing you from going. And we believe that based on your right to private life here in the UK, those factors are outweighing you going back, or we believe that those factors are not weighty, and we believe that you should still be able to go back in terms of making an application under private life. So, in
Okay.
making that balancing act, we have to be sure that those factors are strong enough to cause the immigration caseworker to say, yes, you meet the factors mentioned and therefore will allow you to stay.
Well said, Lawyer Eunice. Right. Lawyer Eunice, all too soon, we've come to the end of this program. But before we conclude, I would like you to just summarize what we've discussed so far, for the benefit of anybody who just joined us and is trying to catch up on what we are discussing. Just a brief summary of what we've touched on so far. Then, after giving us a summary, if you could please leave your contact details for those wanting to contact you for more advice and guidance.
Somebody asked a question, so I just want to quickly
Okay, let's
read
do
it
that
out
then. Okay.
and answer. It's from Jacob Stephen. He says, Lawyer Eunice, you did a
Mm-hmm.
program during the week. Do I still have to wait till 10 years before I can get my indefinite leave to remain? Is it possible to change my 10 years roots now because I just got 2.5 years recently and
Oh,
have already lived here for 15 years before getting the 2.5 years? So, in terms of his question, when it comes to him having to make that application for indefinite leave to remain, unfortunately, if he has not completed a period of 10 years,
yeah.
usually if you're on the 10-year route, you have to complete that period of 10 years before you can make an indefinite leave to remain application. So
Okay.
yes, you may have been here for 15 years. There are people who have been here for 20 years already and they are still on
Mhm.
their 2.5. So
Okay.
especially if you're on the private life route, you can't switch. So for instance, if I was a parent or a partner, after 2.5 years, I can switch to the 5-year route if I meet the suitability and eligibility requirements. But for those on the private life route, they don't have that um, privilege of switching to the 5-year route. For them, they have to remain on the 10-year route until they are able to be granted indefinite leave to remain.
Definitely to remain. Okay.
Yes. And so if you've just been granted uh, 2.5 years, maybe in his case as a parent, because he says he's been here 15 years. So maybe he got it as a parent. He can switch
Mm,
to the 5-year route if he's able to meet the eligibility requirements and the
requirement. Okay.
suitability requirements. Once you
Okay.
switch to the 5-year route, instead of completing 10 years, you'll be completing 7.5 years until you have to apply for your indefinite leave to remain.
To remain.
So
Okay.
if he applied as a parent, then obviously you'll be making the application for indefinite leave to remain sooner if you can switch onto the 5-year route. So in his case,
Okay.
if he's applying as a parent or a partner, he can switch to the 5-year route and get his indefinite leave earlier than expected.
Okay. All
Um,
right.
I hope I've answered this question.
Yes, I hope so.
Yeah.
Yes. So I think that's the only question. Yeah.
Okay. Okay.
Yeah. Mm,
So I'll just round up by saying that in terms of our topic today, I know that there are those who may be looking to make applications under that route. And if you believe that obviously you've lived here for less than 20 years, you believe that you have certain cultural ties here in the UK, you also think that in terms of family ties, you may have extended family here in the UK that you have emotionally bonded with. And when it comes to obstacles to you integrating to life in your home country, maybe there are certain factors. It could be religious, the fact that you are of a certain religion and that religion is not accepted in your country of origin.
mm,
It could
mm,
be that you have a sexual orientation that is not accepted in your country of origin. It could also be that you have a certain form of medical condition which you will not be able to receive the care in your country, and therefore, unfortunately, you will not be able to not only receive care but retreatment as well in your country of origin. And it also could be that there are things going on in your country of origin. That could be a war, or it could be some form of risk to your life, and therefore you are saying that because of these factors, you want to be able to make an application to remain here in the UK. If that is the case for you, do not hesitate to contact us at all at BWF Solicitors. We are located here in the UK at Seven Sisters, and we also do have an office in Ghana as well. But we're located here in London, on the 4th floor of Anna House, 214 to 218 Tottenham High Road, Seven Sisters. Our postcode is N154NP. So N154NP. And our office telephone number is 0208 493 7340. So it's 0208 493 7340. And if you call us from Monday to Friday from 9:30 a.m. to 6 p.m., we can book you in to come and see us face to face or over a Zoom consultation. If, of course, you're looking to call me after the program, my number is 075 35 81 3910. So it's 075 35 81 3910.
Thank you, Lawyer Eunice. We very much appreciate you, taking time off your busy schedule, coming our way to educate us, enlighten us. We very much appreciate it. All too soon, ladies and gentlemen, as I said, we need to end this program. We'll definitely come your way another time. And I believe that you would take the necessary steps in regards to regularizing your stay in this country. Things are getting very tough if you haven't regularized your stay. So please, 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 please take the necessary steps. There are so many options. And I believe that what Lawyer Eunice discussed with us today is one of those options. If you need to know the other options, yes, Lawyer Eunice just left her contact details. Please get in touch with her and she will have a consultation with you. Then she'll be able to advise which option will suit you best. BWF Solicitors, your number one immigration law firm. Lawyer Eunice, thank you so much once again. And I also like to extend my gratitude to the team and head at BWF Solicitors, Mr. Bernard Mowusu. Thank you so much. Next time we'll come your way again with another topic. Take good care of yourself. And please remember to share this program. It's going to be of benefit to somebody in your contacts, and you'll be a blessing on that person as well. So share. Take good care of yourself and stay blessed. Bye-bye.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.